You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Family Lawyer podcast. Today we're talking about pre-nups, post-nups, and whether they're enforceable, whether they've got relevance in society these days, whether they're perhaps even more relevant now than they ever have been. I'm talking about them with Kathryn Cassells, a Senior Associate at Vaitilingam, K. Thank you very much indeed for joining the podcast, Kathryn.
Thank you for having me along. It's great.
Not a topic that I know a huge amount about, if I'm completely honest. And I suspect a lot of listeners have probably got a little bit of hearsay, not as thorough an understanding as perhaps they could have. So hopefully today we can do a little bit of myth busting and an introduction to this topic. In the first instance, so tell us a little bit about yourself and your background and how you've got into the law.
So, as you said, I'm a Senior Associate at Vaitilingam K, and Vaitilingam K is a boutique family firm where we specialise in private family law proceedings. So my day-to-day practice encompasses dealing with finances on divorce or on separation for unmarried couples, private children proceedings, so typically day-to-day arrangements for what happens to the children after the parents have separated, and applications like international leave to remove if one person wants to perhaps go back home or gets a job overseas. Those are quite common children applications that we deal with. And I also have a surrogacy practice. So I've made lots of applications for parental orders following domestic and international surrogacy arrangements. And as we're talking about today, I also spend a lot of my time, particularly in the summer months, advising on and drafting nuptial agreements. So pre-nups, post-nups, separation agreements for couples who aren't married, and rarely cohabitation agreements.
That's a really helpful introduction. Thanks very much indeed. Let's dive right in then. My first question is probably one that you get quite a lot, which is, can a nuptial agreement be enforced? I mean, that's the starting point, is it?
Well, no, not the starting point. So they're not actually enforceable contracts in England and Wales. So couples can draw them up before they get married or after they're married, and the document can set out what they would wish to happen in the event of a divorce, or the very long form that they often ended up being drafted in the event of the permanent separation of the parties, what happens to the finances. But the court ultimately retains the discretion to impose an alternative outcome if it thinks that's appropriate. So even if you've drafted a post-nup or a pre-nup and then you get divorced, what you have to do is turn that document into a consent order, lodge it with the court, and you have to explain to the court in the D81, the statement of information, that summary asset schedule, which is not that summary anymore because it's like a 20-page document. What you have to do is explain to the court how you've arrived at that, and one of the boxes is, are there any other circumstances that you need to draw the court's attention to? And in that box you would say, look, the parties had a prenup or they had a postnup, these were the terms. You'd probably append it and upload that to the court too. But if a judge looks at it and thinks this is absolutely ridiculous, I can't see how anyone in their right mind would have signed up to this document, or I'm really struggling to see how the parties could meet their needs, then ultimately a judge can say, no, I'm not prepared to sign off on that final order and you need to come in and explain yourselves. Or what I think is perhaps more common when you end up seeing reported cases on prenups or postnups and whether they're enforceable or not, what tends to happen is the parties have signed them, then, however many years later they're separating, one party brings out the prenup or postnup because they want to rely on it. And the other party says, no, not happy to rely on that. I didn't know what I was signing up to. I didn't have proper advice at the time. And actually that document doesn't meet my needs. So we need to have a discussion and renegotiate. So then you end up in, quite hotly contested proceedings often, where one person is like, well, we spent quite a lot of money sorting out the pre or post-nup at the time. We agreed, you had advice, these conditions were all met, and the other party's saying, but things have changed and I don't want to be bound by it anymore. What we are finding, despite all of that, is that there has been a movement towards allowing people autonomy to arrange their financial affairs in the way that they think suitable. And although I've talked about the cases where the prenups and post-nups are hotly contested and an issue, what we are finding is that more and more judges are upholding prenups and post-nups in contested cases, provided certain conditions are met. So in every case that I work on, my go-to advice is, if you're not prepared to be bound by this now, in 5 years, 10 years, 15 years, however many years on, don't sign it, because there is a risk that a judge will uphold it.
We're starting to see it become a more accepted part of the process in the judiciary.
Yes, we have. And I think, the key case is Rachmacher. So that's a Supreme Court decision from back in 2010, where the court said, and I'll quote because I'm not going to summarise Supreme Court judges and do them justice. They said the court should give effect to a nuptial agreement that is freely entered into by each party with a full appreciation of its implications, unless in the circumstances prevailing it would not be fair to hold the parties to their respective agreement. So what that means in practice is that, first, every party who's signing up to a pre or a post-nup should have received independent legal advice on the content. So that's why I end up being instructed. Second, that there should be financial disclosure. So what we see as a minimum is a summary schedule attached to the back of the agreement, setting out what everyone's got at the time that you're entering this document. If it's a post-nup, perhaps setting out what's joint property and what you're happy to constitute joint property. So it goes into detail, like how much is in your bank account, how much you've got in your pensions, how much is your house worth, what's the mortgage, if you're likely to inherit, and often inheritance is quite a popular reason to have a nuptial agreement, if you're likely to inherit, what you think you might inherit. Now, quite a difficult conversation to be had, but really important actually that it's documented properly in the nuptial agreement, particularly if that's the whole point of having one. So, if you're going to inherit £100,000, bang it down. If you're going to inherit millions, then it's all the more important that that's properly set out in as much detail as you can. Obviously, no one has a crystal ball. Inheritance isn't guaranteed or anything else. It is important to put down as much information as you can in the financial disclosure sections. The third criteria is that the agreement has to be entered into freely. So it's really important that parties signing up to a nuptial agreement have time to consider and negotiate the content, and they shouldn't be placed under pressure to sign it. So in practice, what that tends to mean for prenups is that they should be signed at least 28 days before the wedding. Now, I think for anyone who's got married, you can imagine the kind of pressure that you're dealing with 28 days before your wedding. And often all of the deposits are paid, you've paid your deposit and everything else falls due about 6 weeks before. So to be negotiating a prenup around that time can be quite stressful. But if you can do it as far in advance as possible of the wedding date, just to make sure that, you're fully able to think it through and have clarity and not be thinking about picking up your wedding dress alongside signing the agreement. And then fourth, and perhaps the most important part of this, is that the agreement has to meet the financial needs of the parties. So what the court doesn't want to be seeing is a document that says, well, I took everything into the marriage, and even if we're together for 15, 20 years and we've got kids, that's all that matters. I took it in and you get absolutely nothing. A judge probably wouldn't sign that off because it wouldn't meet the needs. So how we look at needs in these cases, I'm sure any family lawyers listening to this will know the phrase of needs being an elastic concept, which means that they very much depend on the case and the circumstances. Generally speaking, the longer the marriage, the more generously needs tend to be interpreted. And it's when you're talking about needs that you look at things like the standard of living. So if you've lived in a beautiful family home with 4 bedroom, a bedroom for each child and a spare room, the court's probably not going to say that a 1-bedroom flat meets your needs on separation. So, it's things like that, and making sure that you've covered all of that off in the nuptial agreements. Those are the strands that are coming out from the cases.
Today's Family Lawyer has a sister publication, Today's Wills and Probate, and in that podcast we've talked about lasting powers of attorney, wills, being freely entered into with full appreciation of the information. There is a massive issue with coercion in that space. Is that a similar sort of story here?
So often, actually, yeah, one of the areas that you see when nuptial agreements are being challenged, often there are arguments about coercion. That's why I think it's so important that both parties have independent legal advice. So part of the work that I do is to prepare a really detailed letter setting out the legal framework and, what would happen if you didn't have a prenup or a post-nup, what the impact of that document is, setting out in very, very stark terms as much as you can what it could mean. As obviously no one has a crystal ball. You don't know exactly how much money these people are going to go on and make. But if you're looking at the current situation, you're forecasting, then in some cases a party is potentially signing away millions of pounds. Now you link it again to how close to the wedding a nuptial agreement is being discussed, and if all of your guests are coming within a couple of weeks and it's the choice is sign this prenup or cancel your wedding, then that's that obviously there is perhaps an element of pressure around there. But I think if you've got legal advice and if your lawyer is telling you to air any concerns that you have and to tell them if you are worried, tell them if you're feeling under control, tell them if your partner is saying to you, if you don't sign this, that's it, we're not getting married, and you're worried about the embarrassment. Like I think people really, really do need to trust the lawyers they instruct and be as open as possible with them at the time about the circumstances, because if you end up contesting a nuptial agreement later, what often happens is the file is released from the time setting out the advice. If you've not mentioned any coercion or control at the time, it's perhaps harder to argue it later.
And in the same vein as a will, there are changing circumstances over time as well, because presumably nuptial agreements have to be reviewed regularly.
So you can put review clauses in, but often the document will have, if you don't have a review clause, or if the review clause time kicks in and you choose not to update the document, that doesn't affect the validity of that document. So I think effective drafting of a prenup or a postnup takes into account as much as you can the change in circumstances. So if you're dealing with a couple who are starting out and they're fairly young and they want to have children, then part of the job is to talk to them about what might happen if they were to have children. Do both parties intend to stay at work? Does one party intend to give up their job? And how will that be factored into when meeting their needs in the long term? So in those cases, what we would say is you leave income claims open, because then that means that you can talk about maintenance. So even if you've sorted out the capital, you can still have a chat on separation about what an appropriate amount of maintenance looks like. So there are ways of ensuring that you draft the prenup or the postnup effectively to take into account a change of circumstances in the future. And
you've talked quite extensively about the financials of a nuptial agreement. You look at other things that parents encounter in a marriage. So children, there are ways that you can agree what might happen with any children.
So in terms of the finances, what you don't do in a pre or post-nup is set out children arrangements. The document will deal only with the finances on separation, and then any long-term children arrangements would be dealt with separately, because the court in those circumstances is looking at what's in the best interest of the child at that time. But I think it's important when we're looking at needs to always remember that the court's first consideration with needs is the needs of the children, and to make sure that they have an appropriate home with both parents. So if you have a document, as I mentioned, if the family home is a beautiful £1 million house and the pre or post-nup makes provision for the financially weaker party to end up in a one-bedroom flat, then that's not meeting the needs, and that it wouldn't be in a child's best interest to be going between two homes, which are so stark in comparison. Obviously, it's not always the cases where you can achieve exact financial equality, and nor is that necessarily the right answer. But it wouldn't be good for a child to be going with one parent all the money and the other parent, because they've left the marriage, looks as if they're being punished, and that child's splitting their time between two homes like that. It's not healthy or the right thing, I don't think, as a parent to impose upon them.
Rightly or wrongly, that there's probably an idea that nuptial agreements are the preserve of the rich and famous and the wealthy. Is that true? Is that the case? Is that your practice? Do you see different types of people coming in?
Yeah, lots of different types of people, actually. And I think, if we take a step back and we look at the age at which people are getting married, it's moved on. So if I look at my own friendship group and reveal my age, I think we all started to get engaged and married around 28, 29, 30, getting married late 20s, early 30s. And by that point, often you've bought somewhere together, so you're starting to merge finances if you live together before you get married, or you might have done very well in your career quite early on, or you might have had the horrible misfortune to have inherited. You've had the sadness to lose a parent early, or you've got grandparents who have recently passed and have given money. So I think more and more, I think people are having quite sensible discussions about their finances, and I'm certainly seeing a bit of a mixed bag of prenups. I think there is a bit more in the media about them. I think last week on LinkedIn I couldn't move for posts about pet nups, and we all love our pets. So, so I think people, they just are a bit more on people's radars as a thing that they might get. And I think there is a bit of an element too of, if colleagues you work with who, you think, oh, okay, well, we must be broadly financially similar. Or if if some of your friendship group is starting to talk about getting prenups and the discussions they're having, it almost becomes a bit of a rite of passage to getting married in some cases, I think.
One of the things that I really struggle with family law is that the law simply doesn't keep up with cultural change. So, you're right, people do arrive in relationships now, perhaps with a property or with a pet, or with children, blended families. So this is a conversation that you sort of see that people are having more and more as they come into the relationship.
I think so. And it's really difficult because obviously my experience is skewed by the couples that I'm meeting through work. There's obviously a bit of a discrepancy, because as much as I'm saying couples are having these conversations, we also continue to live in a society where a large proportion of people think that there's such a thing as a common law spouse, and there isn't. And there's a real conflict. So obviously what I say is skewed by my experience day to day, and I am seeing more couples who, perhaps 10 years ago wouldn't have even thought about a prenup coming in and getting a prenup. What I'm not seeing, and what I would love to see, is more couples coming into me and asking for a cohabitation agreement when they're starting to live together, setting out what would happen with the finances. So yeah, I think there is absolutely a mismatch between culture and the law. There's a mismatch between our understanding of the legal obligations that you might have upon entering a relationship, getting married, be that living together, having children together, not married, getting married, having a second marriage, what happens. There's a lot that I think people perhaps just don't know in terms of legal impact. And I really think that everyone would save themselves a lot of heartache if at any significant stage of their relationship, as unromantic as it might be, if they were to pay for an hour's consultation with a family lawyer and just having explained to them like what this means, that would be a really effective and good use of their time, because then everyone's going into every relationship decision with eyes open, but that's not happening. And I also, I won't get on to politics, but I think that family law often falls down the political agenda. It's not always a priority, and I think that's seen and demonstrated quite clearly when you think, back in 2014, coming up 10 years ago, the Law Commission released a report on nuptial agreements, and it's just sat there, and they made loads of really sensible recommendations that should be taken up, and I think would save parties a lot of heartache. Every draft prenup or post-nup that I put together refers to the need that, if it ever becomes law, then you would update it, or that this agreement might be likely to be treated as a qualified nuptial agreement. But nothing's happened. It's just sat there for 10 years. Quite frustrating.
You've taken the words out of my mouth, really, around cohabitation, because of course that's huge now. 1 in 3 first-time buyers are cohabitees as well. Is it the case that a sort of well thought through and drafted cohabitation agreement can then subsequently form some sort of nuptial agreement, or can at least be the basis of one?
Yeah, so I've actually 2 years ago advised on a case with a cohabitation agreement. A year later, they came back and said, "Oh, we're engaged and we're getting married. Can we please update this?" And if you're living together and you're both working, and particularly if you're moving into a property that one person owns, there will have to be, or there should be, conversations around. And as I say, I appreciate my experience is a bit skewed by the work I do and, my own friendship groups and everything else. But, I think that myself and my friends would talk quite openly about, oh, how did you set up the finances when you moved in? Did you open a joint account? Who's paying for what? Are you paying it proportionately depending on what you earn? Are you splitting everything 50-50? If you're having those conversations with your friends, why not have the conversation with your partner? Why not go and see a lawyer and make sure that you know exactly what would happen? And I think particularly for cohabitants, there isn't that protection in place. If you move into a property that's owned by the other person, you don't have a legal claim to it. And often I think, you test out moving together before you get engaged. That's quite a common thing to happen. So if you move into your partner's property and think, oh God, I can't look at those walls anymore. Oh God, that decoration is not to my taste. So I'm going to spend all my savings and get it up in a condition that I like. And then a year later you decide, no, this is not the person I'm going to marry. Well, you're not going to get that money back that you've spent on doing up a property. That's just, you haven't got any protections. One person has to move out and that's it. And yeah, I think, as I say, I think I can look at it from that perspective of seeing it from my friends, but equally I think that the current laws on cohabitation make it quite easy for things like economic and financial abuse to take place within a relationship, where you could string an abusive person could string someone along for years, encourage them to make all the decisions that you might make in a marriage where you've got the legal protections. For example, have children, give up career, don't go back to work, stay at home. In a marriage, you would have some type of protection. If you're living together and there's, you've not had a conversation about what's going to happen, you've got no protection. And that's just wrong.
I absolutely agree. I mean, it is deeply unromantic, of course, to enter into a relationship and start thinking about what might go wrong. And that's not particularly the nature of how we behave in the UK,
No.
but it is on the continent. So, for example, I know in France, there's a much more contractual element to marriage, and it is a slightly more formal process. Presumably that's something that you kind of think that we should be looking at over here.
I think provided there's information and education that comes alongside it. So a lot of European couples you meet who are getting married and living here, for them it's a no-brainer that they're having a prenup. It's a no-brainer that they might think about a post-nup if there's a change of circumstances during the marriage. But that's because they've probably grown up in a society where people talk about the contractual impacts of marriage. Whereas, as I say, here, common law spouse, it's not a thing. Yeah, it's on insurance websites. It's referred to in soap operas, which people watch. It's just not the legal status. And I think there probably is a bit of a, prenups are for rich people. The same way Schedule 1, where you can apply for provision for children when you're not married. Oh, that's for footballers and for their girlfriends. Like, no, it's not. It's for everyone. Like, you can apply. I just don't think that there's enough education around family law in this country.
I wholeheartedly agree on the education point. I mean, look at teaching about opening a bank account. It's something as straightforward as that, understanding what an ISA is. This is a particular soapbox of mine, so I'm not going to jump on it right now. But you're right, there is a fundamental lack of education and understanding about some of these things. And your point about comparison websites having common law spouse on, that continues to rile me
insane. Every time I have to renew the car insurance or the house insurance, it drives me insane. And my poor husband has to listen to me rant about it every time.
But it perpetuates the myth.
Same rant. It does. It does. It really, really does. And it's just not that hard either to change it to living together. Like, it's not hard. Compare the market. If you hear this, change your website.
Well, let's hope that Compare the Market listen to the Today's Family Lawyer podcast. It's been great to have you on to chat about nuptial agreements as well.
Thank you. No, it's funny, you start talking about nuptial agreements, you end up in a big rant about everything else that needs to change. But I do think with these things, ultimately, every couple has to do what's right for them. There are options available to people, but I think, coming back to the whole, if couples saw family lawyers for a meeting before they moved in together or got married, or at least if there was a bit more accessible information or education on the impact of certain decisions you make as a family on your life, long-term consequences, then I think they would have more chance of making more informed decisions as they start new chapters of their life together or apart, as that may be.
No arguments here. Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on today's familylawyer.co.uk. My thanks to Kathryn. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.